I'm a partner in the Warren Allen Law Firm, and today I'm going to talk a little bit about incapacity, guardians, and conservators. Not something that a lot of people like to talk about because unfortunately a lot of people are going to face this with their family members or themselves. So what I'm going to talk about first of all is we're going to talk about what incapacity means in a legal sense. Secondly, I'm going to explain how guardians and conservators are appointed by a court. And thirdly, I'm going to discuss some of the negative and positive aspects of the appointment of a guardian and conservator. So let's first of all talk about incapacity. Generally, people who are legally capable are allowed to make their own decisions for themselves no matter what. And that's probably a really good idea. We are a country that, celebrates freedom. But when that person becomes legally incapable, then the authority to make those decisions has to be transferred to another person. And in many instances, that person becomes the guardian or conservator appointed by a court. When a conservator is required, the court must find that the person is financially incapable. A conservator is the person appointed by the court to manage the other person's finances and property. Financially incapable means that the person is essentially affected by reason of mental or physical impairment to the point where they can't effectively manage their own financial affairs. A guardian, on the other hand, makes personal decisions regarding health and safety. And in order to become a guardian or to appoint a guardian, a court must find that the person's ability to receive and evaluate information effectively or to communicate decisions is impaired to the degree where the person lacks the ability to meet the essential requirements of health and safety. So those are kind of distinctions. Many times, guardians and conservators are the same people, and they are appointed. Guardians often are family members. Sometimes they're professional fiduciaries, in which case there's a fee that's involved. That can be a very important thing, and there's a very important place for them. If you can avoid it, that's nice, but a lot of times it turns out being the best thing for the protected person. So how are guardians and conservators appointed? Well, the court procedure starts with a petition, and almost any interested person, anybody who knows this person or has become aware of their impairment or whatever, can actually file this petition to have a guardian or conservator appointed. Then the petition is filed and it explains why it is that they're seeking a guardian or conservator. And the petition is then served on all of the interested parties, including relatives and caregivers and healthcare providers, people who know this individual, so that they're aware that this is coming in their protected person's life. The court appoints a court visitor that's usually a mental health professional who goes out and interviews all of the people that know this person and comes back to the court with a report and recommending either appointment or non-appointment of a guardian or conservator, and also makes a determination or gives an opinion as to whether or not the petition seeks the appointment of an appropriate guardian, or if they don't think it's an appropriate guardian. If there are objections to the appointment of guardian or conservator or any part of the proceedings, then the matter goes, first of all, to mediation in Multnomah County to see if an agreement can be reached. If not, then it goes to an evidentiary hearing during which the petitioner must have the burden of proof to establish that the person is either financially incapable for a conservator or has become incapacitated for the purpose of guardianship. So we've talked about a little bit how that works. Once the guardian and conservator are appointed, however, they have a number of things that they have to do. They have to report to the court the property aspects of the individual's estate, and they have to ask the court's permission for certain things. They have to do an annual accounting and a whole lot of things. Sometimes they have to post a bond so that the finances of the individual are protected. But in any event, it's a fairly big job, and it's one that's overseen by the court. And it basically works out, and once they're in place, it's pretty hard to unplace them. But there are positive and negative aspects to guardianship and conservatorship. On the positive side, there may be a safer environment for the individual, and they may be less vulnerable to financial exploitation. The family members may feel better because they're in a better situation, and the protected person may be happier with more socialization and less loneliness. On the other side, the negative side, it can take away it takes away the loved one's freedom and independence. It may shatter family relationships big time. It may be extremely expensive that it comes out of the protected person's pocket. And in some instances, it causes the protected person such distress that they may, deteriorate in their condition and circumstances, even to the point where sometimes it might hasten their death. So it is a big deal and something that you need to consider very carefully. So in summary, we've talked about explanation of incapacity in a legal sense, how guardians and conservators are appointed, and explored some of the positive and negative aspects of guardianship and conservatorship. So if you have questions or concerns, I'd be glad to take your calls. My name is Carl Jepson with the Warren Allen Law Firm, 503-255-8795.